Good afternoon, everybody. It looks like most people have signed in for who we have registered, so that's fantastic. My name is Scott Bostley with Benefit Strategy Partners, the managing partner. And thank you for taking the time to participate in today's webinar. It's just one in a series of webinars that Benefit Strategy Partners and McLane Law Firm regularly host, so we hope you find them to be both pertinent, informative, and helpful. Today's webinar will address what employers need to know about unpaid internships. I think a number of high-profile cases have highlighted the risks that non-compliant unpaid internship programs can pose to employers. So that's why we think it might be helpful. Internship programs are sometimes incorrectly thought of as a way to get free labor in exchange for valuable experience. Before bringing unpaid interns on board, employers really should evaluate their internship programs to make sure that they're compliant with all of the requirements for qualifying as an internship program. So by way of brief background, like I said, I'm Scott Bostley, the managing partner of Benefit Strategy Partners, and I'll be the moderator for the webinar. Today's presenter is Adam Hamel, an attorney with McLane Law Firm, which is a full-service law firm with offices in Manchester, Portsmouth, and Concord, New Hampshire, as well as Woburn, Massachusetts. Adam's practice concentrates in the areas of business employment and probate litigation. Before I turn this over to Adam, there will be a Q&A at the conclusion of the webinar. If you do have questions as they come up throughout the webinar, please submit them using the question feature on your control panel, and anytime during Adam's presentation, I'll be able to see those, and at the conclusion, we'll be able to pose those to Adam for responses. So with that, I turn this over to Adam.
Thank you, Scott. I appreciate that, and thank you again, and welcome to everyone this afternoon. Thanks for taking the time to spend some time with us today to learn about unpaid internships. And as Scott said, my name is Adam Hamel. I'm an attorney with the McLane Law Firm, and I practice primarily in the areas of employment and probate and commercial litigation. And this is, I think, the third and sort of what we've kind of tried to have as a quarterly series of these webinars. We've done webinars on the new Massachusetts paid sick time law, as well as on some changes to the Family Medical Leave Act. And if there are any other topics that you'd be interested in hearing more about, including in this series of webinars, do please reach out to either Scott or me and let us know what your ideas are, because we would like to have these sessions be useful to you and informative. So the agenda for today's webinar, what we'll do is I'll begin by kind of giving you a little bit of a landscape of some of the recent litigation involving unpaid internships. And then from there, I'll go into the United States Department of Labor's requirements for what constitutes a qualifying unpaid internship program that's consistent with the Federal Fair Labor Standards Act, which is the law that really governs overtime and exempt and non-exempt employees. And then in addition to that, sort of a related concern is, what are the rules for people who are volunteers working for nonprofits and charities, and that's often another area of unpaid workers. And then, a lot of times these people who are hired as interns can sometimes, most of the time they're college students, but can also be high school students. So something that employers need to be mindful of is, what are the requirements relating to youth employment, particularly in Massachusetts. And then finally, we'll kind of close out with some just a discussion about maybe some of the best practices or pitfalls to keep in mind as you're thinking about designing or bringing on interns. So kind of to set the stage here, we'll talk about how really that internships have kind of have a long tradition of in the business world. I mean, really it kind of even goes back, if you think about it, back to the days of apprenticeships. And people coming on to do work for someone as a means of getting experience and then learning a skill. And so this has always really been seen as a great way for students and younger workers to to get valuable experience, to make connections, network with people, and really just to sort of try on a job or an industry for size. For the employers, it's a great way to to get some good public relations, or build community relations and networking with the with educational institutions. It's sort of a win-win for everybody. But then things kind of changed a little bit during the Great Recession. There was really kind of this sort of perfect storm as a result of the economic hardships that both employers and employees were facing. You had employers who were trying to keep their payroll costs down, probably laying people off, and so, but they still needed to get their run their business, and so you're having people who are really kind of looking to see if there were ways that they could try to essentially get free labor, employees for free. And then on the other side of that, you had young people either just coming out of college or people who had been laid off. These people who were without work but were desperately looking for something, if nothing else, just something to put on their resume. And so people were seeing internships as a way to either just get experience or make a connection or try in some way to land a job. And this seems, again, kind of like a win-win. However, as things go along, you end up with situations where perhaps some of these employers are maybe overreaching and really kind of using these people who they're calling interns as a way to get, as I said, kind of free labor. And then at the end of the process, some of these people who were brought on as interns, if the internship ends and they don't get a job, they feel like they've sort of put all this time and effort, not gotten anything at all out of it, and they get a little bit resentful. And so as a result of that, you end up with some litigation. And really, this all got started in 2011, where a couple of former interns filed a lawsuit in federal court in New York against Fox Searchlight Pictures. And these were people who were production interns on the movie Black Swan, which starred Natalie Portman. And their complaint was, that they were asked to do really essentially sort of menial job duties, like answering telephones, getting lunch for people, making travel arrangements, really sort of the job functions that were typically done by someone who was a paid employee. However, of course, they were not paid. And so they filed a lawsuit under the Federal Fair Labor Standards Act, claiming that they were misclassified as employees. This really kind of opened the floodgates to a slew of other cases against other companies, including the Hearst Publishing Company, magazines like Marie Claire. Also, Condé Nast was hit with a lawsuit relating to W magazine and the New Yorker. The Rolling Stone magazine was hit with a lawsuit, as was interns from Saturday Night Live and The Late Show with David Letterman, Atlantic Records, and Elite Model Management, to name a few. A lot of these sort of high-profile cases are all kind of clustered around the media and entertainment industry, and part of the reason for that is that these are industries that both use and attract a large number of interns, and so there's a good potential in these cases for class action lawsuits. And also they're sort of the ones that kind of get attention because they're well known out there, and sort of in the news outlets really kind of picked up on these. However, as we'll see, even if you're not a large user of internships, even a complaint or a lawsuit by one single intern could really expose an employer to some pretty significant risks. So even if you're not in the situation where you have 100 interns who are suing you as part of a class, the same issues arise and the same risks face you. So one of the problems that we're seeing with this multitude of litigation is that there's been some inconsistent results in these cases. For example, in the Black Swan case, the judge found in favor of the interns. However, in the Hearst magazine case, a different judge, but in the same federal court in Manhattan, found in favor of the employers. So what is the cause of this confusion? And part of that relates to the fact that the most widely referenced and really the only source of guidance for the requirements of what a qualifying unpaid internship is comes from a fact sheet that's put out by the U.S. Department of Labor's Wage and Hour Division. And this is fact sheet number 71, and we'll talk a bit about the details of that fact sheet in just a minute. But really what this is based on a 1947 United States Supreme Court case involving railroad trainees. And what the Department of Labor did in this fact sheet is they really kind of try to interpret the law of that U.S. Supreme Court case and try to apply it into the situation of an internship. The fact sheet itself is not law. It's not a statute. It's not a binding precedent from a court. Really, it's just guidance from a administrative agency. And that's sort of where we get into the problem here, because the judge in the Black Swan case really applied the provisions of that fact sheet very strictly, whereas the judge in the Hearst case only looked at it really as sort of a framework, as guidance for the decision there. Now, these two cases, the Black Swan case and the Hearst Magazine case, they're currently on appeal to the United States Court of Appeal for the Second Circuit. It was argued a couple of months ago, and a decision probably is likely to come out soon, which may provide some answers. But even in that case, I mean, if the Second Circuit does come out with a definitive decision, that would only be binding on employers who are within the jurisdiction of the Second Circuit. And the Second Circuit does not include Massachusetts and New Hampshire. They're in the First Circuit. A case from a Circuit Court of Appeal would certainly be instructive, and it would be helpful, but it would not be a definitive statement of what the law would be. So we really still are dealing with an area where the law is a little bit undefined. So the basic question in these cases involving unpaid internships is really the basic question here is, are interns employees? And it may be surprising that the Federal Fair Labor Standards Act doesn't actually define with real clarity and precision who is an employee and who isn't. The Act instead gives a definition of what it means to employ someone, and that is to suffer or permit someone to work. And really, it's really sort of more that language really relates more to as, basically allowing someone to do work for you. Then you are then their employer, and they are your employee. So basically, any covered and non-exempt individuals who are suffered or permitted to work, they have to be paid under the provisions of the law. So that includes requirements with regard to minimum wage laws and overtime laws. So if someone qualifies as an employee, whatever you call them, whether you call them an intern, whether you call them an independent contractor, if they are an employee and they fall within the umbrella of the FLSA, they need to be paid in accordance with wage and hour laws. So an exception to that, someone who does not qualify as an employee, and this is where the unpaid internship issue arises and where the exemption lies, is that someone whose work serves only his or her own interest is not an employee of a person or an entity who provides aid or instruction. So if someone is doing work in your workplace, but the only reason they're doing that work is to further their own benefit or interest, then they're not your employee. And so again, this is a rule that is derived from this 1947 Supreme Court case. And what the Department of Labor is trying to do in its fact sheet is really kind of to drill that down, that concept of someone who is working for his or her own interest, and to how that fits into an internship situation. So we'll move on now to the actual 6 criteria for a qualified unpaid internship program based on the Department of Labor's fact sheet 71. So again, there's 6 criteria, and what those criteria are is that the first one is the internship, even though it includes the actual operation of the facilities of the employer, is similar to training which would be given in an educational environment. The second criteria is that the internship experience is for the benefit of the intern. The third criteria is that the intern does not displace regular employees, but works under the close supervision of existing staff. The fourth one is that the employer that provides training derives no immediate advantage from the activities of the intern, and on occasion, its operations may actually be impeded. So by having the interns, they're not necessarily, it's usually a burden upon the employer to actually have the interns working with them. The fifth factor is that the intern is not necessarily entitled to a job at the conclusion of the internship. And then the sixth factor is that the employer and the intern understand that the intern is not entitled to wages for the time spent in the internship. So the Department of Labor's position on this is that if all 6 criteria are met, there is no employment relationship under the FLSA. But again, as I said, the fact sheet in and of itself is not law, and so this is where the distinction between the Black Swan case and the Hearst case came in. Is that the Black Swan judge really did say that, yeah, you need to meet all 6 of these criteria strictly in order to qualify. And in looking at these criteria and how they work together, the Department of Labor is taking the position that, because the definition of the word employ is so broad, by necessity, the exclusion to that has to be very narrow. And so that's why they've placed these 6, pretty specific criteria. And then sort of the bottom line from the Department of Labor's point of view is that they're basically advising employers that, for the most part, more often than not, any internship in the for-profit private sector is generally going to be viewed as employment. So that's the Department of Labor's way of telling employers that we think it's going to be pretty hard for you to actually meet all of these criteria and really be able to have an internship that is not a paid internship, or to have people working for you who you're not paying as your employees. So drilling down a little bit into kind of what some of these factors mean and how they actually apply. So with regard to the first factor about similarity to education, some of the questions that you'd want to ask yourself in terms of, are you meeting this criteria, is the internship program structured around classroom or academic experience, or as opposed to the employer's operation? So are your interns, are they sitting in seminars or sort of a classroom type formal training program more often than not? Is there materials that they're being asked to read? Are they being given lectures about different topics? And or are they just kind of working on your on your production floor? Are they working in your office? The more similar to a sort of traditional classroom type of educational experience that the program is, the more likely it would be determined to be a qualifying internship program. Similarly, is the program overseen by a college or university? Do participants get academic credit? Those are factors that, again, the more involvement that the program has with an educational institution, the more likely it is that it'll be determined to be a qualifying internship program. And then this is an important one, is that are the skills provided applicable to multiple employment settings, or are they simply tailored to the particular employer's operations? So the training that you're giving to your interns, is this training that relates to your own company's systems or products or services? Are you teaching them how to sell the product that you have? Are you teaching them how to use your own accounting system? Or compared to that, are you giving your interns for general sales training or general management training? If it's the latter, if the training that you're giving them is really kind of broad-based and they could use it either in working for your organization or for any organization, that kind of general training is going to be more likely to be seen as qualifying for an internship program. The next factor is focuses on who is really benefiting from the internship program, and the benefit, really the primary benefit, has to be for the intern themselves. Any benefit that the that the employer gets really has to be really de minimis and incidental. And really, as I mentioned before, in most instances, in a real, true qualifying internship program, it's really going to be actually, a burden or an inconvenience to the employer really to offer that program. So, does the intern perform routine work of the business on a regular and recurring basis? Is the business dependent upon the work of the intern? So again, here it'd be one thing if, ask yourself, are you having your interns work on some sort of a general market research project, or are you having them work on, an actual client pitch that you're putting together? Is their work product something that your business is actually going to be, using and is counting on? If it's, like I said before, sort of just general market research that they're doing, which may have some incidental benefit to you, that's going to be more likely to be, the kind of project that would be found to be consistent with a qualifying unpaid internship. But you should know that, and this is something that the Department of Labor points out, is that the fact that a person receives training does not in and of itself exempt them from the Fair Labor Standards Act if they're also engaged in the operations of the employer and are performing productive work for the employer, like filing clerical work. So for instance, you can't necessarily, take, your receptionist and say, well, I'm just going to, give my receptionist, send her to marketing training, and therefore, I've provided her with training, and she incidentally does some other work, so that's going to qualify. The position of the Department of Labor there is that that's really just not going to fly. The question of, whether or not the intern is displacing employees, and really this is, you can't be, substituting interns for your paid employees. So what we're looking at here from the Department of Labor's point of view is, are interns being used as substitutes for regular workers or to augment the workforce during specific times? And the things you'd be looking here is, do you use your interns to cover lunch breaks, or if you have a particularly busy time during the day, is that you relying on your interns to fill in that gap? And that's really going to be something that would not be looked on well by the Department of Labor. Another question asked is, if you have some work that the interns are doing, and if the interns weren't around, would you need to hire someone else to do that job, or would you need to ask your existing staff to work more hours to do that work? And if the answer to those questions is yes, then from the Department of Labor's point of view, those interns are not really interns, but they're employees. And then this is a situation, this last bullet point is a situation where something is more likely to be found to be an internship. If the person is merely job shadowing under the close and constant supervision of another paid employee, if you have an intern who follows around one of your salespeople, or who works very closely with this, really watches what one of your existing employee does, and just kind of learns by watching, then that's probably okay. If, on the other hand, you're having the intern, go out and actually meet with clients or customers by themselves, and in the supervision that you provide to them is not really all that intensive, then that's probably less likely to be something that is going to be a qualifying internship program. The issue of job entitlement is an important one. Ask yourself the question of, does the internship have a fixed duration established prior to the start of an internship? The notion of kind of an open-ended internship program that has really kind of no set end is going to be less likely to be found by the Department of Labor to be compliant. I mean, the idea here is that I'm going to bring this intern in for a period of, let's say, 3 months over the summer, and we've got this, sort of set out training program that we're going to be using. You're going to accomplish these particular goals, and at the end of the program, it was really nice working with you. We hope you, gained something valuable from this, and, thank you very much. So no guarantee of any kind of employment at the end of the internship. Again, also, what the Department of Labor is discouraging employers from doing is trying to use an unpaid internship as some kind of a trial period or some sort of extended job interview during which the employer is sort of trying on someone for size with the notion that if you do well during this internship, we'll hire you at the end. And that's really not, from the Department of Labor's point of view, what we're trying to accomplish with internships. And really, during that sort of trial period, the person is acting as your employee and needs to be hired as such. So that's really kind of what the 6 factors are, how they work out, the kind of questions that you want to ask. And really kind of the bad news is that what I kind of started out with is that the kind of the bottom line from the Department of Labor's point of view is that if you are a for-profit company in the private sector, the message from the Department of Labor is really that you're going to have a very hard time justifying that this person is someone who qualifies as an unpaid intern. And really, what they're looking for is they want people to be paying their interns as employees and classifying them as such. Now, what if you are in the public sector, or if you're a nonprofit? Can't you have people who work for you for nothing as volunteers? And the answer to that is generally yes. The Department of Labor, in that same fact sheet 71, says that unpaid internships in the public sector and for not-for-profit charitable organizations where the intern volunteers without the expectation of compensation are generally permissible. However, what you should note is that this really, is not, this is the position of the Department of Labor. It's not anything that is, documented in a particular statute or case law. And if you look at actually what the Federal Fair Labor Standard Act says, it really only includes some pretty limited specific exemptions for volunteers. And what those exemptions are is people who volunteer for a state and local government agency, so that would not cover private nonprofits. And then the only other specific statutory exemption for volunteer work is for people who volunteer for humanitarian purposes at a private nonprofit food banks. Other nonprofits that are not food banks are not specifically included in the statute. And this amendment to the Fair Labor Standards Act was sort of something that Congress added to address a particular specific need, and they really kind of only wanted to limit that that application. I mean, the reality is that probably what the Department of Labor is saying is that in general, they're not going to be coming after nonprofits who are using sort of legitimate volunteers, but that there is sort of that uneasiness that there's no real formal legal authority for that position. And this is sort of an issue that came up recently, even within the last couple of weeks. There's been some criticism that Hillary Clinton has had to deal with regard to the Clinton Foundation. There's been some news reports about the internship practices of the Clinton Foundation. Generally, during the summer, they have as many as 100 or more interns, and these are people who work 30 or 40 hours a week, and they get the only compensation that they get is a $2,000 stipend. And the issues that are being raised here is that people are sort of asking questions about that particular internship program and whether or not it's compliant, because some of the things that could be problematic is that if you have someone who you are designating as a volunteer, but you're giving them any kind of payment over and above just reimbursement of out-of-pocket expenses, well then that's a little bit problematic, because it starts to look like, even if you call it a stipend, it starts to look like wages. And if it's if this $2,000 for the whole 3-month period is looked at as wages, that's going to be well below the minimum wage, and it could be problematic. And then another thing that could be problematic for nonprofits who are using volunteers is if you have people who you're calling volunteers and they're doing the same kinds of tasks as other people who you have on your payroll are doing, again, that could be problematic. Well, what's the difference between these two people? Why are you paying this one person and not paying another? And so some of the suggestions or best practices for nonprofits in that regard is that, you should be using your employees, your paid employees, for one set of tasks, and then if you have volunteers, you have them do a completely different set of tasks as opposed to overlapping. The Department of Labor Wage and Hour Division, it says that it recognizes an exception for individuals who volunteer their time freely and without any anticipation of compensation for religious, charitable, civic, or humanitarian purposes to nonprofit organizations. But so again, you want to make sure that you're mindful of these problematic things, that to make sure that if you are classifying people or considering people as volunteers, they really are actual bona fide volunteers, and that you're mindful of kind of the problem areas that could arise when you have both volunteers and employees. So with regard to the issue of youth employment, particularly as it relates to Massachusetts, and this could, this could come up in, people who you're, if you're, treating them as interns, or even, I thought it kind of fit nicely into the topic that if we're, interns are usually hired over the summer, and sometimes people will also hire temporary youth employees too. So I thought it would be useful perhaps to have kind of a little bit of a brush up on this. And under Massachusetts law, there are specific restrictions preventing children under 18 from working in certain hazardous industries or with certain dangerous equipment. So, if you're an employer that has, you fall into one of those categories of having a particularly hazardous industry or, dangerous equipment, you want to make sure that you're mindful of what those restrictions are. And also, if you have youth employees, you want to be mindful of the restrictions on the hours and numbers of days per week that youth can work. And so specifically with regard to younger workers, children 16 and under, they're not allowed to work during school hours in Massachusetts, and the children between the ages of 14 and 16 cannot work more than 6 days per week. And they can't work more than 8 hours per day in any day for a weekly maximum of 48 hours per week. And then specifically with regard to children under 16, they cannot work before 7 a.m. or after 7 p.m., except that during the summer, they can work until 9 p.m. And with regard to kind of the older teenage workers, children between the ages of 16 and 18, they cannot work more than 6 days per week. And they also, with limited exceptions, such as the minors are not allowed to work more than 9 hours per day for a weekly maximum, again, of 48 hours per week. And then these older teenagers, 16 through 18, they can't work before 6 a.m. or after 10 p.m., except that minors who are employed during the summer or on Fridays and Saturdays at restaurants, racetracks, can work until midnight. So that's kind of a little bit of a brief kind of overview of the scope of the law on youth employees. So if you are going to be employing youth over the summer, you want to just make sure that you're mindful of those requirements. So here's kind of where I get to the end here about some of the pitfalls you need to worry about with regard to potential problems with an unpaid internship. And this is where I talked at the beginning about these large employers facing class action lawsuits. But here, even if you are a smaller employer and you have just one intern, they can still cause large problems for you if you are run afoul of the Massachusetts Wage Act. And that's because the Wage Act, it includes a prohibition against any kind of what are called in the statute special contracts, exempting compliance with the statute. So aside from a bona fide qualifying unpaid internship program, any arrangement under which someone works for free in exchange for experience is problematic. So, again, you can have the situation where, this is a win-win for the young worker and the employer says, well, you can do this for me, and you're going to get, valuable experience for that. The young worker could be, all on board with this, think this is a great idea. But however, if things go bad at the between them, or just whatever, or even if the Attorney General's office were to come in and audit your wage and hour practices, you'd have a big problem there, because even that consensual agreement between the employer and the intern would still be violative of the Wage Act. You can't, by agreement, exempt yourself from the Wage Act, and this is where the consequences here are particularly concerning for employers, because the Massachusetts Wage Act includes automatic triple damages, and with regard to it doesn't matter if you're acting willfully or in bad faith. I mean, if you violate the Massachusetts Wage Act, the law and the cases that come out under the law are very specific about automatic triple damages, and also particularly worrisome for the owners of smaller companies is that the principals of the business have personal individual liability under the Wage Act. So an employee who says they have a claim under the Wage Act can sue both the employing entity, but also the principals and certain managerial employees of that entity. Something to be considered about. And then with regard to if you are a out-of-state based employer, but you are hiring people who you're calling interns within Massachusetts, the Massachusetts Wage Act could still apply to those people as well. So, kind of the thing that I'd like to leave you with before we open it up to questions is really, again, the sort of the basic warning from the Department of Labor is that in most circumstances, any kind of for-profit private employer is really going to have a hard time justifying that they have a qualifying unpaid internship program. And really, as with all things in life, there's no such thing as a free lunch. There's also, no such thing as a free employee. So with that, I would like to open it up to any questions that any of the participants may have.
Great. Thank you so much, Adam. Very useful information. So we will open it up for questions. If you do have one, please use the question feature in the control panel and submit it. And I'll state the question and leave time for Adam to answer. We actually do have a few in queue here, Adam, so I'll throw one out if people are still going to be entering questions. The first one, with all of this being said, is the best course of action to just treat all interns as employees?
I mean, I think that given the sort of the unsettled nature of the law, and we've got all these kind of conflicting cases. We're looking for a case coming out by the Second Circuit Court of Appeals, but again, that would not be binding here in Massachusetts. Generally speaking, probably the wisest course that a lot of employers are going to find is that maybe the best thing to do is really just to to hire these people as employees, pay them the minimum wage, and then that in and of itself, if you're paying the minimum wage, complying with overtime laws, then that in and of itself kind of acts as a safe harbor, and really kind of protects you from the uncertainty of whether or not down the road you're going to face a wage claim or an audit from either the U.S. Department of Labor or the Massachusetts Attorney General on your wage and hour practices. So perhaps it may be that in consultation with your own employment attorney, when you're looking at these kind of programs, that it may be for many employers that the best thing is just to instead of having unpaid interns, just have them added to your payroll as employees.
Fantastic. So one other question that came in, Adam, are summer interns eligible for my employee benefits program?
So I think that what you want to think about is, if we're talking about if the person really is an actual bona fide intern, if you've satisfied yourself that your internship program qualifies as an unpaid internship program, then I think the answer to that would be no, because then by definition that person is not an employee, and so that they wouldn't be entitled to employee benefits. However, if the decision is, yeah, I'm going to treat this person as an employee, then you really kind of run into the rubric of temporary employees. And so I think that, under those circumstances, you would treat them like you would with any other temporary employee. And, by policy, you can, discriminate against temporary employees versus permanent employees in terms of, who you're going to provide fringe benefits to. You may have situations where, in order to qualify for health insurance, you need to work a certain number of hours, you need to be employed for a certain amount of time. Same thing with vacation benefits. Again, so, those kinds of fringe benefit programs, I think, are going to, be based on your policies. With regard to some other things, for instance, statutory benefits that are provided to employees or protections that are provided to employees under the law. One thing that comes to mind in particular is the recent Massachusetts earned sick time law. That anyone who is an employee from day one begins to accrue earned sick time, from the moment that they're hired, starting on July 1st, 2015. And so, you can, by policy, say that, you can't use any of your earned sick time in the first 3 months of employment, and that may cover the whole time that this intern is working for you. But even though they may not actually qualify to actually use that time, they still would be entitled to begin to accrue that time, and that would apply with any of the other kind of statutory protections that are provided to employees. So any kind of benefits that are provided under the the ADA or or other in the anti-discrimination statutes like 151B. So those kinds of things that all employees are entitled to would cover your interns as well. But again, your fringe benefit programs, you would treat them in the same way you would any other temporary employee.
Perfect. Okay. And I think that last part of the question, the last part of your response there answered one of the other questions was, do summer interns count towards determination of under statutes such as FMLA and the mass sick time? So.
The one thing I would add to that bit, though, Scott, is that with regard to when you're talking about trying to determine if you as an employer are covered by the Family Medical Leave Act, or if you are required by for instance, the sick leave statute to provide paid or unpaid sick time. Those are considerations that relate to the number of employees that you have. And and these interns, I think, would certainly be included in determining whether or not you meet those thresholds. Gotcha.
Okay. So I think that's it for questions for now. What I would say, though, by all means, if you have questions that come up after the webinar is over, please feel free to send them to either Adam or myself. We'd be happy to take those and look at them and answer. And actually, I think we have 2 questions that are just coming in now. So we'll get those asked and see if Adam can respond to those. So the first question, Adam, does Massachusetts require youth employees to have a work license from their school? If so, is this true for summer work?
Yeah, so you would want to just check the statute and check with the local education department in your town. But the answer to that question is that the work certificate requirement that applies to youth workers who are 16 and under. Actually, and now that I'm saying that, I think it's actually who are under 16. So I think it's employees who are 14 and 15. So if you have someone who's under the age of 16, then they would be required to have a certificate, and that's something that you would get from. I believe that you get that from the, for instance, the school authority in the town that the employee lives in.
Okay, perfect. And the other question, Adam, is for youth workers, does not working during school hours relate only to days hours when the school is scheduled and running? For instance, does it exclude working summer weekdays and scheduled school vacations?
Yeah, that's my understanding of what that means. Basically, what they want to do is that if you have people who are working for you who are under the age of 16, which is the age under which the law requires people to be in school. So when school is not in session, then you are able to have people who are under the age of 16 working in your business. Yeah, so that only applies to times when school is in session.
Okay, perfect. Okay, so it does look like that's all we have for questions for now. As I said, feel free to reach out to Adam or myself with any questions after the webinar. We'll be happy to answer those. And I would just like to reiterate what Adam mentioned at the beginning of the webinar. If you have any specific topics that you're interested in, please feel free to let us know. We will be conducting these on a regular basis, and we'd be happy to put a webinar together for that subject matter. And I'll just conclude my remarks by saying thank you, Adam. I found that to be very interesting and useful. And hopefully everyone enjoys the long weekend. Adam, any final comments?
Other than just to thank everyone for participating, and thank you, Scott, for moderating. It's always a pleasure to do these with you, and I look forward to the next one.
Perfect. All right, great. And I believe that concludes the webinar. Thank you, everybody.